Hello, ni hao, and welcome to our webcast. Today we will be discussing Chinese patent law and practice, views from a recent visit to China. If you would like to submit questions to us during this presentation, you can submit them through the Q&A box at the top of your screen in the lime green bar. My name is Deirdre Sanders, and I have 20 years experience as a patent lawyer. My background is in biotechnology with a focus on genetics and biologics, and I represent clients of all sizes from small startups to Fortune 500 clients. I also represent clients in litigation. Further, I am on the board of the Boston Patent Law Association. One of my partners, Mark Solomon, will be introducing himself shortly as well and will participate with me in this webcast. As you can see in this picture, we had the honor of speaking at a state intellectual property office of the People's Republic of China, otherwise known as SIPO, in Beijing this spring. The 30-plus examiners with whom we met were gracious and enthusiastic hosts with a keen interest in discussing U.S. patent law and the America Invents Act in particular. Patent law is relatively new in China. It was enacted in 1984 and began in 1985, so fewer than 2 generations have been living under patent law in China. China's patent law is strongly based on European law, but is also influenced by U.S. law. The SIPO office we visited in Beijing was one of the many offices of SIPO. This particular office was located between the 3rd and 4th ring roads in Beijing. It is not far from the Forbidden City, which is located within the 1st ring road. As you can see, the A in the circle on the upper left of this map represents the location of the SIPO office, and the B circled in the middle of the map is where the Forbidden City is located. So as you can see, they are not very far apart. So this is an area full of culture and history. The topics that we will be discussing today include filing considerations for filing your patent in China, examination considerations for prosecuting your patent in front of SIPO, monetization of your patent IP rights, and enforcement of your patent. And now Mark will take us through the first topic.
Hamilton Brooks Smith Reynolds. I practice in the engineering arts. I have 15 years of patent law experience and 10 years of experience in electrical, software, control systems, optoelectronics, and signal processing. I'm a past president with the Boston Patent Law Association, and in my practice, I represent small startups, mid-sized companies, and Fortune 500 companies. I draft and prosecute U.S. patents with a strong team of colleagues and develop and execute worldwide patent strategies. Our firm has a trusted relationship with foreign associates around the world, including, of course, China. We're going to start some of the topics with filing considerations. To begin the process, we'll introduce a hypothetical example that Deirdre and I worked up together. And in this hypothetical, we have humanized therapeutic antibodies. We could also have antibody drug conjugates, methods of disease treatment using SAME. And in this hypothetical, we have an optoelectronic system for observing those antibodies. Looking at the actual system, so we have an imaging system, we refer to it as. So we have a sample that is imaged via a lens assembly into an imaging subsystem. We have an image processor and a data processor and a graphical user interface, GUI, and which the user can interact with each of the subsystems and processors. So we're going to look first at some examples of considerations for China entry. In this set of examples, we'll consider entry from the U.S., but it could be any country around the world. We'll focus on the U.S. because our firm is located here in the Boston area. And we have, starting with one thought that people should consider is a 12-hour time difference between Boston and Beijing. So one should consider that if it's Friday morning in the U.S., it is already too late in the week to send instructions to Chinese associates who handle patent matters before the State Intellectual Property Office of China on behalf of foreign applicants. Notably in California, it's 15 hours in a graduated scale between Boston and California. A consideration for China entry could be the market. So one should recognize that currently, I just checked this morning, China has about 19% of the world's population. It is the highest populated country in the world, over 1.3 billion people there. So if you have a product that is very commercializable, you might be considering China as a market. Another consideration for whether you should enter China with a patent is whether you have, there are patent law considerations. Examples of such considerations include whether you have patentable subject matter and also timing for whether or not there's been a public disclosure. Other considerations might include the thought of manufacturing. So as most people may know, is that a patent can be used to preclude others from manufacturing a claimed invention. China, as most people know, does have quite a strong manufacturing industry. While Deirdre and I were in China, we did observe firsthand some of the electrical engineering manufacturing plants, the chip manufacturing. We also observed some biological manufacturing areas. Another consideration is license agreements. So your company may have license agreements in a patent application, and that license agreement may specify a variety of countries around the world. One, especially in-house counsel, should be cognizant of whether or not a license agreement does require maintaining patent protection in a country such as China. And of course, there's always the marketing aspect of a company, especially small startups, where patent protection could be very attractive to investors. As we mentioned before, China does have a large share of the world's population, so investors may be very interested either now or in the future in obtaining some market share, and it's always good advice to have patent coverage in a place where you have a large market. Another consideration is enforcement. Enforcement is improving in China, as we'll discuss later, but that's a consideration whether or not your patent technology is an area where there is stronger patent protection and enforcement in a country like China. So I mentioned before that there are some timing considerations. The first consideration is there is a requirement for absolute novelty. So if you have, an inventor has publicly disclosed an invention, that would destroy novelty in a country such as China that has a requirement for absolute novelty. Meaning that the invention cannot be publicly available before the filing date of the patent in China. It's anywhere in the world, and there is no distinction between prior publications and prior use. So actual use of an invention prior to securing a filing date would prevent filings in China and obtaining patent protection. There is typically no grace period in China. There are some limited exceptions. And China, in those limited exceptions, does allow for a 6-month grace period. So there are a few exceptions here without the consent of the applicant. So if the inventors were working under a non-disclosure agreement and the receiving party of the information publicly disclosed in some manner the information learned under that non-disclosure agreement, that would be without consent of the applicant. The applicant would have 6 months to file. There are some requirements, such as evidence may be requested, and declarations supporting evidence may be required for that, and also the other two exceptions, the first of which is a meeting organized by the State Council of the People's Republic of China, or Chinese Academic or Technological Association may also have that meeting, in which case there would be the 6-month grace period, and also there is a 6-month grace period for where the inventor is invited to speak at an international exhibition by the Chinese government. One should take away from this information that there's effectively no grace period except for very narrow exceptions.
The next question to consider is whether you have patentable subject matter. For example, like in the United States, there are a number of categories that are treated as patentable or non-patentable. In China, those categories include scientific discoveries, rules or methods for mental activities, methods of diagnosis or disease treatment, and plants and animal varieties, for example, transgenic plants or animals. Also, substances obtained by means of nuclear transformation are not patentable subject matter, nor is any invention that is considered contrary to the laws of the state or social morality or detrimental to public interest. It should be kept in mind, however, that in some cases, careful claim patenting will permit you to proceed with patent protection. For example, for plant and animal varieties, although the plant and animal varieties themselves are not patentable, processes for manufacturing or producing them are. In addition, with regards to methods of diagnosis or disease treatment, Swiss-type claims, such as in Europe, are permissible subject matter. For example, a claim directed to a method of preparing a pharmaceutical, such as use of a substance X for the manufacturing of a medicament, or use of a substance X for the manufacturing of a medicament for the treatment of a disease, would be treated as patentable subject matter. Let's turn back to our hypothetical. In this hypothetical, you can see that we have again put out an image that represents the hypothetical inventions of our potential applicant. Going through the various potential inventions that could be entitled to patentable subject matter consideration are the humanized antibodies. These are likely patentable. The antibody drug conjugates, again, likely patentable. Methods of treatment of the disease with the antibodies or with the conjugates, likely not patentable. However, the Swiss-type claiming would permit some protection should those patents be allowed. The system would likely be patentable. However, the software per se would likely not be patentable, although its technical effects would be. Your next consideration would be what types of patents are available and what types of patent applications should you file. As you would probably know, in the United States, there are 3 typical types of patents: the utility patent, the design patent, and the plant patent. In China, they have an invention patent, which is quite similar to the utility patent. They also have a design patent similar to our design patent. They do not have a plant patent. However, they do have a type of patent known as a utility model patent. Utility model patents are also located and available in other jurisdictions, but not in the United States. As you can see, the terms of the invention patent in China are comparable to the term of the utility patent in the United States. Similarly, the design patent in China is similar to the design patent term in the United States. But keep in mind with the utility patents that in the United States, applicants may be able to obtain patent term adjustments and patent term extensions. In China, unfortunately for the applicant, no patent term adjustment or patent extension is available, even if marketing and FDA type approval takes a long time to get, or even if there are delays in the patent office, at this time, such extensions of term are not available. So let's compare the invention patent versus the utility model patent. The invention patent undergoes substantive examination. Therefore, it is entitled to a greater presumption of validity because an examiner has spent the time and effort to consider various aspects of the patentability of the patent claims. A utility model patent, on the other hand, does not undergo such substantive examination, but merely undergoes formalistic examination. What does this end up meaning for the resulting protection that can be conferred? Well, the invention patent confers a greater presumption of validity because of the extent of consideration and examination in the patent office versus a lower such presumption for utility model patents. The term of an invention patent, as we discussed on the previous slide, is also longer. However, due to the substantive examination, the process for obtaining the patent is slower, typically 3 to 5 years to grant versus less than 1 year quite often for the utility model patent. Again, because of the slower time and more substantive examination, it is more expensive in general to obtain an invention patent than a utility model patent. Another major difference between invention patents and utility model patents, in addition to the substantive examination, is the subject matter that can be covered and obtained and patented under each system. For an invention patent, there's a diverse and variety of subject matter that can be claimed, including methods, chemical compounds, structures, and biologics, just to name a few. For the utility model patent, on the other hand, only limited subject matter would be available, specifically products with a defined shape or structure. Another type of patent which can be obtained in China is the design patent. The design must be distinctly different from existing designs or combinations, as you would expect. They're relatively quick to obtain and have a 10-year term, which is quite useful for conferring added protection to inventions that would qualify for such coverage. They require a brief description of design and in addition would involve the submission of drawings, typical 6-side views and a perspective view, computer-aided design images or photographs are acceptable. You can have multiple design drawings in one design patent. So there are a number of different types and ways that the claimed subject matter can be presented.
Now, we do have some breaking news with respect to Chinese design patents. According to a new change that was effective just this past May 1st, it is possible to protect computer graphics by way of design patents if they involve a graphical user interface and the graphics are for implementing a specific function. So question is, can computer graphics be protected by any of the invention patents, utility models, or design patents in China? And so the answer here is just in the design patents. The objects to be protected shall meet 2 conditions simultaneously. First condition is the human-machine interaction, and the second condition is realizing the product function. So the human-machine interaction refers to the process of information such as instructions, feedback, status, transmission between a human and the machine through certain means such as a click, a touch, a slide, a display, that type of thing. And realizing the product function means that the graphical user interface to be protected is of benefit to product functions, including realizing its built-in functions and realizing functions with the help of application programs. However, there's exclusion to just linking functions to web pages. So referring next back to the hypothetical, we'll take another look at this imaging system and take a look at what Deirdre had talked about, a little more detail about invention patents and utility model patents, and I just went over a few details about design patents. So in the humanized antibodies and antibody drug conjugates, the types of patents could be invention patents only. System operating features would be invention patents only. Software technical effects would be an invention patent only. The system mechanical features could be potentially all three types of patents: the invention patents, utility model patents, and design patents. And the graphical user interface, as I just described, would be design patent only. So priority claims to an earlier application, of course, everyone wants that earliest filing date. And so quite often here in the United States, we will file the application and then, of course, ask clients whether the client would like to seek international protection. And so we'll have a priority base. We can file a PCT application, or we can file a direct national application. In the case of the PCT application, that's Patent Cooperation Treaty patent application, we can file that application, and then within up to 32 months, it's a 30-month country is China, with a possibility of an additional 2 months with a small extension fee. And then you could enter China with the priority claim back to that U.S. and PCT filing dates. Another approach is file the U.S. application and then within 12 months file the application in China with a priority claim. And that's for the invention patent and utility model patent. For the design patent, there is no priority basis back to a patent cooperation treaty application. But you will have 6 months from, say, a U.S. filing date to claim back to the priority of that U.S. design application. Notably, design patent applications cannot claim priority to invention or utility model applications. So a few filing tips to think about here is to remember that China has a first-to-file system. As many of you know, that the United States just adopted a first inventor-to-file system. So when it comes to China, you really do have to think, I want to be the first to file my patent application. And you do want to leave some sufficient time for a quality translation. If there are errors in the translation, you may have difficulty down the road for having subject matter fully within that Chinese patent application. So you do want to leave the Chinese associates some sufficient time. Typically, we like to leave a month or more, so we do try to get instructions early from clients. Be aware of a Chinese holiday where the State Intellectual Property Office of China is closed. For example, Chinese Labor Day, and particularly if you are interested in using the application as a priority document, just last year in 2013, April 29th through May 1st was the Chinese Labor Day holiday. That was Monday through Wednesday. We did have a client who was going to attend a trade show on the Monday of the 29th. The instructions came late. The invention was realized a little late in the game, and so we were told we must get priority. One issue here is that we do, both China and the United States, both need the export control. They have export control license requirements. So in a case where there are joint inventorship from U.S. inventors and Chinese inventors, you must first get an export license from one of the countries. In that case, we were able to get the export license from the United States. We did have to file in Chinese language upon filing, and we did have to beat that Monday, April 29th date of 2013. We were successful. We had some outstanding Chinese associates who helped with the translations and, in fact, filed on the Sunday, April 28th. So all was good, but that does emphasize a little bit of pre-thinking to make sure all goes well. Sometimes it just cannot be avoided. A small issue that just came up for me last week was that we do need to provide inventors named in Chinese characters if applicable. In this case, we had a U.S. inventor, professor who was originally from China, and we did have to obtain his name in Chinese. So we've talked a bit about utility model patents and an invention patents. And in the case where the subject matter could be claimed in both, which is structure and shape, that you do have a choice. And you start to think, well, maybe there is some strategy I could use, because as Deirdre had mentioned, the utility model patent application is not substantively examined. There are formalities that are looked at, whereas the invention patent application is substantively examined. And you can see from the bar chart at the bottom that the difference in estimated timing of pendency, less than 1 year for utility model patent and 3 to 5 years for invention patent applications. And so your utility model patent application, which could be the exact same specification and drawings as your invention patent application, in this case issues first within the 1 year. We do have a time where the utility model patent is pending as an issued patent, but then you have to realize that there is a requirement that you cannot have double patenting in China. And as I mentioned, in this case, there could be a situation where you're claiming the same structure. And so timing-wise, the strategy would go that you have utility model patent issue. It would be available until your invention patent issued, and at which time you would have to allow your utility model patent to go abandoned. And so as Deirdre mentioned, you have 10 years for that utility model patent, so the timing between when it went abandoned and the final length of time where the utility model patent would have been enforced would be abandoned. However, you are then left with what might be even stronger protection in the form of that invention patent. And again, that lasts for up to 20 years.
The next topic we will be discussing is examination considerations. Assuming that you have decided to proceed with patenting in China and you know what type of patent you'd like, you next need to go through the examination process. And like this picture of the Great Wall of China here on this slide, there's a long and winding path sometimes to achieving a patent grant. As we'd mentioned, we'd had the honor of visiting SIPO's offices and learning a little bit more about the state intellectual property office. Like the United States now has, there are multiple offices for the SIPO. We met at one of the offices in Beijing. The applications are randomly assigned to the different offices by computer, and you cannot request a specific office to examine your patent application if you're an applicant, unfortunately. Currently, there are 10,000 examiners, but they're hoping to double that amount with 20,000. Each examiner is typically required at this time to reach a decision for up to and approximately 100 patent applications per year. The examination process involves an initial preliminary examination, basically to check for compliance of formalities, a substantive examination, re-examination if required, court action if required, and hopefully for the applicant, patent grant. The preliminary examination procedure basically looks to see whether there is proper subject matter for the type of patent being requested, whether there are any obvious defects, and things of that nature. The system for amending claims in China, in some senses, is quite strict. Amendments of claims can occur at the request for a substantive examination. Further, claims can be amended within 3 months after notification of entry into the substantive examination and at any time when requested by an examiner. In addition, post-grant amendments are generally not allowed unless they're just merely a correction of an obvious typographical error or in response to an invalidation action, deletion of claims, or combining of claims. As in Europe, inventiveness and inventive step, similar to United States obviousness, is one of the considerations of patentability in addition to novelty, which Mark discussed previously, and industrial applicability. Inventiveness involves an assessment of whether the invention has prominent substantive features and represents a notable progress above and beyond what was in the prior art. The examiner's analysis is similar to the European problem and solution approach, and expert declarations are rare but possible. For example, when the expert is opining with respect to the technical difficulty of combining different documents in the prior art in a manner which would make obvious the applicant's claimed invention. Sufficiency of disclosure and enablement are also considered and assessed by the Chinese patent examiners. For example, with regard to a disease or disorder treatment, in some situations, disclosure of the effect of the treatment may be sufficient, but often in other situations, particularly when the pathogenesis of the disease would not be one of known or common to one of ordinary skill in the art, more experimental data would likely be needed, more than just the effect of treatment. Moreover, please keep in mind that post-filing data is generally not admissible to support sufficiency of disclosure and enablement. It may be possible to submit such data if it's in a printed publication that's being submitted, but not merely applicants' own experimental data. That would be considered a lack of sufficient disclosure in the patent application as filed. Also keep in mind that broad claims are generally not allowed in a patent application when only one embodiment is disclosed. So keep this in mind when you're drafting your specification in China, and consider including multiple embodiments as long as you can sufficiently show sufficient support and enablement of those multiple embodiments and that other conditions of patentability are met. Re-examination procedure in China is not the same as re-examination procedure in the United States, so it's a little confusing that that term is used. In fact, re-examination procedure in China is more similar to a United States appeal in the Patent Office. It's conducted in Beijing offices by the Patent Re-examination Board, otherwise known as the Board or the PRB. Currently, that board is backlogged, so keep that in mind that it may extend the time to get your patent application, but then again, it may be the only way you can get your patent application. About a fifth to a quarter of re-examinations are decided in favor of the applicant, though, so it's likely worth it to at least make the attempt if this is important claimed subject matter for you. Furthermore, if the applicant is dissatisfied with the decision of the board, further legal proceedings are available to continue to pursue their rights and challenge the decision. However, fewer than 5% of those proceedings are successful. The SIPO examiners also gave us a few examiner interview tips. First of all, generally, examiner interviews will not be granted before the first office action. So you may want to plan a strategy of waiting until after the first office action and likely after you've filed a reply to request one. Participants would include the examiner and can include an applicant and or a legal representative, but they requested try not to have more than 2 people. It's preferable to not have a lot. It also should be noted that the examiner may invite a director or other senior member of SIPO to participate in the interview. Any new documents should be submitted in advance, and we were warned that if you bring new documents to the interview that are surprising to the examiner and were not expected, did not follow the proper protocol of submitting them prior, this may actually cause the interview to be cut short. So be careful to make sure that the examiner has been provided with all necessary documentation before the interview. Also, generally, this type of examiner interview is not conducted by telephone, but is preferably conducted in person. We also discussed the relationship between SIPO and the court system, as it is clear in the United States that the Patent Office requests public comment from different sources when a new regulation is in question. The same is true for SIPO. SIPO invites public comments, especially from the courts, before major changes are enacted, they informed us. In addition, the SIPO and the courts meet annually in multiple forums throughout the year, so they have additional times to get to know each other and to discuss different patent matters relevant to changes in the rules or the regulations. Courts do give deference to SIPO regarding the validity of granted claims for invention patents as well.
We're now going to look at monetization issues in China. So we did talk about filing considerations and examination considerations, and now either you have still a pending application or an issued patent, and so what most people want to do is to try to monetize the value of it. And so one issue here that was a bit interesting is sort of on the compensation side of the ledger for the employee inventor. So there are some statutory requirements for rewards or awards that will apply for the inventors. So companies should try to clearly specify a level of reward for patent inventorship in China. And also a level of reward can be specified in an employment contract or employee handbook. The reward is higher if the patent is practiced or used to generate revenue. So some examples we were given by one of our Chinese colleagues was that within 3 months from the patent grant, the inventor should be rewarded with at least 3,000 yuan, which is equivalent currently to $500 for an invention patent, and at least about 1,000 yuan for a utility model and design patent, and that's about $160. While it sounds like a little, it will increase dramatically if there is some level of commercial success. So companies in China should be prepared to pay no less than 2% of profit due to exploitation of the patent for invention or utility models, or 0.2% for design for the inventor. If the patent is licensed, the company should pay no less than 10% of the license fee as remuneration for the inventor. And again, currently it is 6 yuan for every $1. So continuing to look at the monetization, one issue that we also have here in the United States is assignments, making sure that the client does in fact own the rights to the patent. Unlike the U.S., however, the assignments are required to be in writing in China, and the assignments must be registered with the State Intellectual Property Office to be effective, and that does take effect from the date of registration with the approval from SIPO. So that is a little bit different. In the U.S., it is not required. It is preferenced by most U.S. practitioners that there is a recordation at the Patent Office, so it's evident to the public there is some public notice. Another issue for monetization is licenses. So the license must be registered with SIPO within 3 months from the effective filing date, the effective date of the agreement. And those terms in the license agreement should be written as completely and clearly as possible. So this is a matter of public record. One of the Chinese colleagues that we met with, who was a former examiner, did some data research and did find that between 2008 and 2012, utility models actually accounted for approximately 50% of the approximately 10,000 patent license agreements that were on file with SIPO. So you can see that there is some ongoing activity in China, that there is monetization occurring. There are real licenses happening with respect to patents in China. And also patent pledging is becoming more widely used in China. Some further studies that were done with respect to pledges in China included, in 2011, there was one case in which there were 6 utility model patents that were pledged for 18 million yuan, which is equivalent to approximately $3 million US. Another case study was in 2011, there was one utility model patent that was pledged for approximately 600,000 US dollars, 1.8 million yuan. And just recently in 2013, 7 utility model patents were pledged for approximately 6 million yuan, which is approximately 1 million US dollars. So you can see that there is some real monetization occurring in China. Another interesting issue is a compulsory license requirement that a third party could request to obtain a license from a party, a patent holder, who has either not exploited the patent or is exploiting the patent in a manner in which is using unfair competition. This does apply to both invention and utility model patents. You can see on this chart that there are a few other time frames after the lapse of 3 years from the date when a patent is granted, or 4 years, and 4 years from the date when the patent application was filed, that if there was no exercise in order to exploit the patent, commercialize, monetize the patent for a justifiable reason, that a third party can seek for a compulsory license in order to take advantage of rights under that patent.
The last topic that we will be discussing today is enforcement. Assuming that you have successfully gone through the process of filing your patent application and obtaining an enforceable patent and hopefully monetizing it, you now may be needing to enforce it against potential infringers. The litigation trends in China that we learned about were, first, that litigation is almost doubled in some cases in the patent field, from approximately 4,000 cases in 2008 to almost 10,000 cases in 2012. However, in Beijing's #1 Intermediate People's Court, there's a relatively stable number of patent cases at this time. It should be interesting to note, however, that design patent cases dominate, with invention and utility patent cases being about equal. There are 4 main enforcement options should you feel that someone is infringing upon your rights in intellectual property. First, there's administrative enforcement. Administrative proceedings are usually quick and inexpensive. They can take place, for example, in SIPO for patent issues, as we discussed. And it should also be noted that to obtain a complete strategy for enforcing your rights, you should also consider trademark and unfair competition and copyright rights you may have as well. For trademark and unfair competition, you would enforce your administrative rights in the Administration for Industry and Commerce, and in the Copyright Office for your copyright infringement rights. Furthermore, you can proceed with a customs action, civil litigation, and in some cases even potentially criminal prosecution. Chinese authorities may be more likely to take action to encourage foreign investments in some cases, we were told. Also, according to one source, claimant win rates in Beijing and 4 other major cities are encouraging, although damage awards are not on the same scale as in Europe, UK, for example, or in the United States. A positive outcome can be a useful means for obtaining evidence for use in subsequent civil litigation. For customs action, recordation is required and a bond is required as well. Other litigation considerations are: consider that electronic evidence is becoming increasingly popular in IP litigation in China. China also has the prior use defense and the Bowler type exception. The prior use defense works like this: making a product or using a process prior to the date of the application and continuing making and using the produced product or process only in the original scope may confer a potential infringer with a prior use defense. With regard to the Bowler type exception, producing, using, or importing patented medicine or patented medicinal equipment for the purpose of providing the information required for an administrative examination and or approval is likely not going to be considered infringement. So that brings us to the end of the substantive portion of our discussion, but perhaps the most important slide of all is us providing proper credits and disclaimers. We wish to thank the following people for meetings in April of 2014 that we discussed during this webcast, during which the information from this webcast was provided. The patent examiners we met with at SIPO, the patent attorneys registered to practice before SIPO who had hosted us, and the patent litigation attorneys we met who are admitted to practice before the courts in China. We, the speakers, are registered to practice in the United States, but we certainly rely on the guidance of the Chinese patent lawyers and for filing or for any kind of patent enforcement or obtaining in China. The content of this webcast is not legal advice and should not be construed as such. Any opinions expressed in this webcast reflect only the present views of the speakers. Sheshe, thank you. Questions? We will now take questions from the audience. There are several questions that have come in. Let's start with this one. Are file histories publicly available? The answer to that question is no, patent file histories are not publicly available. Currently, they are only available to a limited extent and after issuance. The dates of the actions may be available. Another question that came in is, can a PCT patent application serve as a priority document for both a utility model application and an invention patent application in China? The answer to that question is yes. A PCT patent application can serve as a priority document for both a utility model application and an invention patent application. The next question on our list is, can patent applications claim priority to a PCT application? I'm going to turn that question over to Mark.
So the answer to that question is no. A PCT application does not cover design applications, so design applications cannot claim priority to a PCT application. I should say a Chinese design application cannot claim priority to a PCT application. Recall that I had mentioned earlier that design applications cannot claim priority to utility model patent applications or invention applications. Another question that we have received is, can design patents and utility model patents claim the same subject matter in China? So the issue here is there a double patenting issue as there would be for invention patents and design models in China? So this was interesting. This one we did make sure we checked. We do want to make sure that it's understood that the answer is no. Design patent applications and utility model patent applications and their corresponding patents would not have the issue of a double patenting. Design and patents and utility model patents are directed to protect different aspects. They cannot claim the same subject matter, so there's not a double patenting issue for design and utility model patents as it would be for invention and utility models. I think we may have mentioned this earlier. Can the same application and claims be filed as both a utility model application and an invention patent application in China? And in this case, the subject matter is assumed to be directed to a shape, structure, or combination thereof. So here the answer is yes, you can file both a utility model application and an invention patent application for the same patent, for the same invention.
Another question that came in is, when are annuities due in China and how do they work? Annuities are due to SIPO after a patent is granted. They are then subsequently due every year within a month before the anniversary of patent grant. Annuities are less expensive for utility model patents and design patents than they are for invention patents. And this factor actually should be a part of your consideration as you proceed to monetize your invention. So it's a good question. Now, not only should you be considering this fact that you're going to have to pay annuities every year, but you're also going to need to keep in mind that the life of your invention may be such that it only lasts a certain amount of time as far as the patent, the life of your patent. The life of, sorry, let me say that one more time. The life of the product that you received the patent for may only have a certain length of shelf life. And you need to consider whether the monetization of the patent is worth it for you to continue to pay the annuities. This is true in other jurisdictions as well. But you need to keep in mind that you will be paying more for certain patent type rights than other patent rights, and you need to consider that as part of your process, particularly if you have a large portfolio.
Another question here that came in is, do U.S. employers have obligations for statutory rewards to their employees who are Chinese citizens with regard to Chinese patents commercialized? My understanding is no. I think the laws would apply to the organization and where that organization is located. But it does make some sense to double check on this one with a practitioner in China. So, but my inclination here is that no, because the Chinese laws would only apply to those organizations that are established and fall under Chinese laws. There is another question here. Is it still possible for a non-inventor to obtain a patent in China for an invention that was pursued in other countries but not filed from the inventors in China? There the answer is no. I'm not aware that it was ever possible to do that for a non-inventor to obtain a patent in China for an invention for which this person, third party, did not create that invention, because we do have the obligation, definitely before the U.S. patent law and other offices around the world, that we get inventorship correct. So I'm not sure if that was fact or fiction, but I don't believe that is possible to do.
Another question that has come in is, what is the state of personalized medicine in China? For example, diagnostic methods. Exactly. Well, that's a good question. In fact, we did discuss the United States Myriad and Prometheus cases with the Chinese patent examiners, and they were well aware of those cases and following them closely. They're also following whatever is going on in Europe and around the world and looking at that issue closely. What I would say is, as you know, methods, we mentioned earlier in the program, methods of diagnosis are difficult to get unless you can somehow get your invention into a Swiss claim form. So while I think it's worth it to try to come up with proper claim language and work with your Chinese patent agent or patent lawyer to develop claims that may at least cover some aspects of your invention, I think at this stage it is quite difficult to get personalized medicine and diagnostic type inventions covered under Chinese patent law. But perhaps there are other elements of the inventive subject matter that would be subject to possible patent rights, but it will be difficult. Another question that has come in is, does enforcement versus infringers vary widely depending on the region of China? Well, we did not ask that specific question. It does appear that there is a great deal of regional variation in China among the different courts that we could, from the information that we were able to obtain, and in terms of the practices and the kind of decisions there are. So I would believe that there is a wide difference. And Mark, I believe you may have some points on that as well.
Yes, one of the Chinese attorneys we met with does have a very interesting strategy with respect to these infringers, is that you must take action, and you must take continual action on an ongoing basis. And this particular example that we were told about was that this client had about 100 infringers and sought about 100 actions simultaneously, and just kept working at it and working at it, so that the infringers who could disappear and start up again somewhere else relatively easily in China became too much of a burden. I mean, they used customs activities, they seized properties, machines, and eventually what we've been told is that the infringers would decrease and possibly move on to other goods. But that was this one strategy that we were told was working out successfully.
Mark, I see that there is an export license question that you may be able to opine upon. Is it possible for a non-inventor to obtain a patent in China for an invention that was pursued in other countries but not filed by the inventors of China? That is not the export license question. But let me see. You can go back to that one. It's okay. Let's see that. Where did it go? Let's go to the export control license one, then we'll back up to the other one. That's, at one time it was required that an application for inventions made in China be filed in China before being filed in any other jurisdiction. Does obtaining an export control license satisfy the requirement if it still exists?
So my understanding of that question is, if an invention is made in China, the question is, must the export license be obtained? And the answer is yes, that is still the case. There are particular situations when it's defense-related that failure to do so could be punishable very severely. And it could also be that any patent, first of all, any patent that's filed outside of China without that export license would be unenforceable inside of China, and we have similar regulations here in the U.S. But so one must be careful with that export license, again, both in the U.S. and China. So be a bit careful with those activities.
Well, we've been told that we are at the end of our 1 hour presentation. So we will be stopping now and finishing our webcast. Thank you so much for joining us. And please join us for our next webcast. Think your company's trademark will be difficult to protect? Tips for registration of the most difficult trademarks. That will be on June 24th from 12 to 1 p.m. Thanks again, and Sai Chen.